Thank you very much for the kind introduction, and thank you to everyone for being here today, for spending your Saturday in this way. I'm really excited to be talking to you today. I'm looking forward to it. So I just want to maybe begin with a quick overview of what it is I plan to present to you today. Basically, the focus of my work, or the work that I want to talk to you about, is called Bodies in Motion. And I've called it a relational approach to copyright law and choreography. But I also recognize that in order to sort of take you with me through my thinking about copyright and choreography, I want to back up a little bit and make sure you have some of the fundamentals of the copyright law, the concepts and doctrines that define copyright, so that you can come with me on this journey. So what I plan to do is to introduce, first of all, these basic requirements and concepts of copyright. So this is going to be your sort of Copyright Law 101. So I apologize for the sort of the brevity and the sort of deluge of information that you'll get here, but the good news is that there won't be an exam at the end of it. And then what I want to do is give you a sort of summary or some perspective on what I call the relational theory of copyright. And this is really the sort of theoretical lens that I bring to understanding and to criticizing our copyright law structures. And then I'm going to turn to the topic that's at hand. So that is the use of copyright to protect works of choreography or dance. And I'm going to use some examples from sort of popular culture and other examples you'll be aware of or ought to be. And I'll use those examples to begin to challenge some of those central concepts that I've introduced you to. So challenging the idea of authorship, originality, and legal or sole ownership in relation to choreographic creativity. Okay, so that's the plan. As for the strategy, what I'll probably do is just talk at you and hopefully keep you engaged enough with some videos and some clips of what I'm talking about. But I welcome questions or interventions as we go, and I'll try to be sure to leave some time as well at the end for any remaining questions or discussion that you might be inspired to introduce. So, okay, that's the plan. Questions or concerns? Okay. So the subject of copyright is very different than what it was, or it would have been even 15 or 20 years ago. What I find now is people are really aware of copyright law in their everyday lives. Copyright is everywhere. It protects many of the cultural texts that we encounter in our daily lives. Everything from movies and music to software and videos. All of these are protected by legal rights, and we tend to take that for granted, or at least that we accept that it is so. And the language that we hear in relation to copyright also feels kind of natural and inevitable. So we hear about authors' rights, ownership, property, we hear about infringement and theft and stealing. But copyright law protects vast swaths of our cultural landscape. And we've seen that new technologies, new cultural practices are turning vast proportions of our citizenry into infringers and unlawful actors and even criminals. So part of the reason why this might seem okay to us, if it does, is because there's a version of copyright that most people understand. It seems kind of intuitive, it just seems kind of fair. Authors work hard, they have rights over their work, they can stop people from copying without paying for it. Okay, seems fair. But what I find is that the closer you look at copyright law, how it actually works, not just in practice in terms of power and industry structures and so on, but actually in terms of concepts. How do we turn movies and music and intellectual works into property, into commodities, and then create legal rights in relation to them? The closer you look at that, the more complicated it becomes, the less intuitive, the less it seems to make sense. Okay, so hopefully what I'm going to do today is just shed enough light on some of these problematic assumptions to actually trouble some of your understandings about copyright law and how it works, some of your intuitions, and maybe to prompt you to look again That's something you might have come to take as a given. Okay, so with that said, let's start on our Copyright 101. What is copyright? It is, simply put, the right to copy. That's really it. So that means the right to reproduce expression. And it belongs exclusively to the copyright owner or persons authorized by the copyright owner. It also includes the right to publish a work for the first time, and it includes the right to perform a work in public. So remember, if a work is protected, you can't perform it in public or even record yourself performing it in private, unless there are exceptions or legal defenses that might apply to you. Okay. What does it protect? To what does it attach? Well, copyright subsists in Canada for, I should say, the life of the author and 50 years after the author dies. And it attaches to every original, literary, dramatic, musical, and artistic work. Okay? The work itself is the intangible work of expression. Okay? So there's not really a physical thing there, though we need a physical manifestation of it, but it's the intangible expression that is the subject matter of this exclusive right. We could work through each category. Each category of work comes with its own interpretive challenges. You can imagine lawyers and judges debating what is music? What is art? That gets messy. For our purposes, let's think about what are dramatic works. There are lots of queries and questions that come along with interpreting drama, what is dramatic, and that has often related to what is choreographic. Choreographic works, dance, is a subcategory of a dramatic work. Okay. And as we'll see, there were lots of questions initially about whether it can be dramatic if it doesn't really tell a story, for example. So, and also, dramatic includes cinematographic works. So that means films, like Hollywood movies. Okay. But it would also include if you pick up your iPhone and film someone doing a dance. They might have copyright in the dance, if they created it. That would be the choreographic work. But the person who picked up their iPhone and filmed it would have copyright in the cinematographic work that recorded them doing the dance. And as we'll see, there are also performers' rights. So you already have 3 layers of rights in that one video of someone dancing. I haven't even mentioned they're dancing to music. So you have copyright in the music that they're dancing to. Who has that? The person that composed the music. Okay. So, and then you have the person that performed the music. They might have rights as well. Suddenly, in one tiny work, you have 10 or 15 different people who have rights and interests in that video, who can control whether it's reproduced, whether it's performed in public. Okay, so that's just to give you an idea of the way that these complicated concepts start off being kind of intuitive and then quickly become absurd. Okay, in my opinion. Okay, so now, even if something fits into the category of a protected work, we still have to ask, well, is it a copyrightable work? There are 3 core concepts here: originality, the idea-expression dichotomy, and fixation. Okay, so just quickly, the Originality Doctrine says we only protect original works. There's no definition of original in the Act. What do we mean by original? Well, we mean it's not copied. Well, what does that mean? Well, it means you kind of thought of it independently, you wrote something independently, you didn't reproduce any other source. Okay, that's original. Is that enough? Could that just be that you worked on something but it's not really original? Should we ask for something more? Should we ask for creativity? Should we ask for novelty if we're going to give this monopoly? Well, the Supreme Court tells us it doesn't have to be novel or unique. We just ask that you exercise some skill and judgment. That means the use of your knowledge, some sort of ability, some capacity for choice. It's really a very low threshold. The other thing is, even if you have lots of stuff in a work that is not itself original, you might still have an original work if you've used originality, skill and judgment, in the way you put those things together. Okay? So musical chords, for example, they're common, they belong in the public domain, but if you arrange musical chords in a way that involves some skill and judgment on your part that isn't copied, you've created a new work that copyright protects. You cannot then lay claim to the public domain material that you used, but you have copyright over the compilation. Idea expression. Okay, so even although people often say, they stole my idea, you can't actually own ideas. If you can't own them, you can't steal them. So in a copyright case, if someone says you stole my idea, they may as well say, but you didn't infringe my copyright. You only have copyright in the expression of the idea. Okay? So that's pretty easy to state, but then how do we distinguish between ideas and the expression of ideas? Where's the line between what we protect and what we refuse to protect? The best way to think of it is that ideas are abstract, they're general, they're vague. Expressions are more detailed, refined, more specific, developed. So we're not going to protect themes, styles, concepts, genres, but we're going to protect particular stories or tunes and so on. Okay, so in other words, no one can monopolize the 12-bar blues, but Johnny Cash can own the Folsom Prison Blues. Okay? No one can monopolize the idea of star-crossed lovers, but Arthur Laurent can own West Side Story. But when the next person comes along and writes a musical about star-crossed lovers, is it an original work? Or is it reproducing some of the expression or just the idea that you find in West Side Story? Okay? These are the things that copyright lawyers spend their time arguing about. And the truth is that there is no line. Okay? Where you draw the line between idea and expression is entirely arbitrary. Depends what you want to protect, which depends if you think the defendant has done something wrong or the plaintiff deserves to be protected. Okay. I'm still on this sheet, I'm afraid. Yes, the Fixation Doctrine. So this basically means even though we're protecting intangible works, music, drama, we need some physical manifestation of that work to know what it is. So, in other words, when you write something down on a manuscript, when you paint it on a canvas, you have a physical thing so that copyright law can vest. Doesn't protect the physical thing, it protects the intangible expression, but you still need that physical thing to perfect the legal right. So if I just dance a dance, there's no copyright protection in that, even if it's an original dance. But when I film myself dancing a dance, I've recorded that dance. And that's what perfects the right. I don't have to go register it anywhere. I don't need to get someone to give it the stamp of approval that it's original. That's when the right becomes a right that the law recognizes. You with me? Questions? Okay. No questions, right? All perfectly clear. Sorry, yeah.
I noticed I'm a retired computer programmer, and I used to just put copyright and year on the document that I created. Yeah. Is that sufficient?
It's no. It's also and it's also kind of irrelevant. So it comes from a practice actually where in the US there was a requirement of formalities, there was a requirement of registration to secure protection, and so it became just good practice if you wanted protection in the US that you had to do the copyright notice and the year and so on. It's next to meaningless in Canada. So in other words, you either have copyright or you don't, based upon the application of the principles and the doctrines that exist. Just saying you do doesn't make it so.
But it may make somebody cautious.
It makes somebody cautious. So it might change other people's behavior. It doesn't actually change or affect your rights, but it might at least notify other people that you intend to assert those rights. So that's where it's relevant.
How do you take it to the next step? Do you actually have to register it somewhere?
You don't have to. You can. So there is a copyright register at the CIPO, the Canadian Intellectual Property Office. But whether the fact that you're on it is really, again, neither here nor there. It gives you a presumption in your favor, but it's as soon as someone says, actually, they don't have copyright, we're back to the beginning. You have to prove that you have it. The fact that you've registered it, it's not relevant. So it's funny because it's very different from patent law. Like people they get the two mixed up often. Patent law protects inventions, especially in software. It's messy, that distinction. But in order to have a patent, you can assert, yes, it has to be registered. For some trademark rights and brands and logos, registration gives you new and different rights. In copyright, registration legally is as close to irrelevant as it can be.
Just to be judged later by some court.
Exactly. Exactly. We presume copyright exists, and it probably does because the threshold is so low. But whether you own it, whether you have a right to assert, it's not affected by the fact of registration either way.
You're okay to assert it even though you don't know.
Sure, you can try. Most people do. They just send a cease and desist, and that's usually enough, right? Yeah. Okay, so then we have this question of who owns copyright, and the answer again is simple. The author owns copyright, unless they've transferred it to somebody else. So there's a presumption as well that the author is the first owner of copyright. It might be the person that wrote it down, but not necessarily. So in the example I gave you, I did a dance, someone else filmed it with their iPhone. I am the person who's the author of the dance, even though I'm not the person responsible for its physical materialization in the video. Okay? So actually it's about from whose brain did the work emanate? From whom did it originate? Will tell you who is the first owner of copyright. And the law likes there to be one. Sometimes we can allow there to be two if they both agreed and they both acted as independent authors and their contributions merged. But usually if someone's claiming to be a co-author, we're suspicious.
Is date an issue there?
Is what? Date. It can be, but it becomes an evidentiary issue, right? Who did what first and who was where when. So just the usual laws of evidence in terms of proving it. But how to prove from whose brain something came, especially imagine the context of a musical band and they get together, like they jam out some stuff in the studio and then they have a falling out. Well, do they still get to use that guitar riff if the person doesn't want them to use it anymore? Is that a separate copyrightable work, or was the whole thing a joint work? Who owns the product of their collective labor? It's messy. And then finally, I just want to add that there are these neighboring rights. So I mentioned a performer's performance. That's relevant for our subject matter, which is dance. The sound recording maker has a right in a sound recording. A broadcaster has a right in communication signals. These aren't really copyright because they're not authorial rights. We don't recognize these people as authors. But in the Act, we still call it copyright. The rights that we protect are slightly different, and we treat it separately. But nonetheless, this is responsible for this layering of different kinds of rights. And finally, moral rights. So what I've described so far are economic rights to control copying. Authors, and now since 2012 performers, also have moral rights, which means that they can protect the integrity of their work. Which means that if it's mutilated, distorted, modified to the prejudice of their honor or reputation, then they could prevent that use of the work. Oops, it's just water. So, Da Vinci's work with the moustache is a good example. It's out of copyright now, so it wouldn't be relevant. But what can you do to distort another person's work without the author taking offense and saying you're not allowed to do that? And the right to be associated with the work as the author is the right of paternity or the right of attribution. What's interesting, especially in the dance context and many other contexts, authors often say, or artists, I just want them to have my name. They actually feel that being associated with the work as the author is the more important thing. Okay, so it's not necessarily about controlling copies, but about recognition. So the question then is, why do we have copyright? This is all that remains for me to cover before we get to move on to the paper. This small question. Why do we have copyright? So I suggest here, and it's, I think, commonly agreed, that there are two main themes. Either we have it because it's a right, or we have it because it's the smart thing to do. Okay. So if it's a right-based theory, then we focus upon the natural entitlement of the author as an intellectual laborer. So there are some, especially in the English law, sort of Lockean language about the fruits of one's labor, the right to own what one labored to create. And also in the European tradition, there's more of a focus on the investment of the personality of the author. It's much more romantic, because the Europeans are just more romantic in general. But the result is the same. In a way, you end up with a right, a natural right, that the author can claim to control the fruits of their intellectual labor. On the other hand, and this is the sort of a US model, where they're much more utilitarian, we grant copyright to serve a social purpose. Okay. What we're doing is we're deliberately trying to use the law to create an incentive to encourage people to innovate and to create for the good of society. Okay. So then we're only going to grant the rights that we need to grant in order to incentivize the creativity that we want. You don't have any sort of natural entitlement. This isn't about fairness or justice. This is just about what works for the public. Okay. As you can imagine, depending on which model you take, you end up with a very different looking system of intellectual property or copyright protection, both in its application and in the development of law and policy. Okay. As for Canada, as usual, somewhere in between. A little from Britain, a little from America, a wee bit from France. So we have, coming from the Supreme Court, either a balance or a muddy, messy compromise, depending on who you ask. We're told by the Chief Justice that the Copyright Act is a balance between, sorry, it was Justice Spinney, if anyone cares, a balance between promoting the public interest in the encouragement and the dissemination of works of the arts and intellect, and obtaining a just reward for the creator. So we have the idea of justice, the just reward for the creator, but we also have the idea of the public interest. And the role of the court in Canada and the government, in fact, is to ensure that we are trying our best to meet both ends when we create, when we construct, when we apply copyright law. Okay, so questions? Concerns? All right. So let me march on then. Oh, sorry.
Beyond Canada and the United States, when we get into Europe and parts of Asia, what happens?
Every jurisdiction has a slightly different take on this, and so the Europeans tend to be much more authors' rights. They have the droit moral, so they focus on authors' rights. They have very limited exceptions. It looks very different from the American system, which tends to have narrower rights, broader exceptions. And then we do have an international regime, which is aimed at creating a degree of harmonization / Americanization. So, so what increasingly happens is that there is a sort of race to the top, like more and more protection to protect. And it's funny, because once you get to that international trade level, what happens is all the concepts we're talking about, authors and originality and encouraging creativity, it just translates into a commodity in the international market like any other, and one where America happens to be a net exporter. And then we just treat it as such. Yeah?
Slight explanation here. From the beginning of your talk, you're giving a relational approach to copyright.
Mm-hmm.
Where does choreography begin?
Choreography?
Yes.
We'll get there. I know I'm still on foundations. I promise we'll get there. But I could tell you everything that's wrong with applying copyright to choreography, but if I hadn't told you about copyright, you wouldn't really necessarily be able to follow me. So that's the plan. Okay, I'm moving. Here we go. Okay, so this is the last piece of the puzzle that I want to give you, which is that relational approach part. So this is just to say that my work has focused on thinking about how copyright works, whether it's the best way for us to achieve the social purposes, the public goals that we're trying to achieve, whether this legal monopoly helps or might hinder cultural dialogue and creative practices, whose speech becomes property and whose speech is silenced as infringement. So the first part of my book focuses on authorship, and that's really where I'm going to be focusing my attention going forward, thinking about who the author is, what's wrong with the law's understanding of authorship, and how it might be better understood. Okay, so my suggestion is that there's still, in our law and in our discourse about the law, a romantic idea of the author as the individual, laboring away in the garret. And that conception of authorship does translate into the way we understand our law and the way we apply it. It legitimizes the idea of the author as owner. It creates a moral divide between the creator, this worthy laborer, and the copier, who's just a free rider or the infringer, and not necessarily recognized as a creator in their own right. So it diminishes the value of creative reuse, transformative reuse, which is becoming such a key part of our cultural interactions, especially in the digital age. Overview. Okay, so the main points are authorship is not independent. Authorship is dialogic. It happens in the context of a cultural conversation. It's situated. It's contextual. Copyright's work is not just a piece of property, like any other piece of property. Copyright's work is actually speech. It's expression. We have rights to that too, and they look a little different from the property structures that copyright law creates. Users, especially transformative users or downstream creators in the cultural conversation, should be given some freedom to participate in that cultural dialogue, to join the conversation, and not just be silenced as infringers or as thieves. So then how do I get there in any particular project? What I tend to do, I find myself doing, is thinking about, well, how are people actually creating? How are they actually engaging in their culture? How do people understand their own creative processes? How do they interact with other works within that sphere? And then how does this map onto or clash with the legal concepts that we have at play? Okay. Which takes us to choreography. Okay, and so there's actually an awful lot of work has been done in this vein, thinking about, for example, hip-hop music or even computer software programming, the ways in which people actually create together collaboratively, or the way that they sample and reuse other music, and the way that our intellectual property or copyright legal structures don't reflect that process of creativity and the problems that causes. So you have the free software movement, you have lots of open source software just saying this is not how software is created. It's created in massive teams. It's a continuous process of improvement. It's not one person typing code. Okay. Similarly, hip-hop music evolves by looking around you, by taking samples, by integrating those, by using other people's music as your own raw materials to produce your own. That doesn't map onto our legal structures. So what I want to do in this project is think about choreography and dance, because we don't tend to think about copyright and dance. And there's something even interesting in that simple fact. But I also want to look at how copyright law and its central concepts struggle to deal with the world of choreography or the world of dance, and maybe draw out then some lessons, some dance lessons, for copyright law that we could apply more generally. And it's a thing that I've spent, well, I'm excited about the project because I love dancing. I don't do it very well. But I've spent a lot of my life trying, and part of that trying is trying to copy what other people do. Copying it badly, but trying to copy it, trying to perform it. Now, copying and performing other people's work is exactly what copyright law tells us we shouldn't be doing. So I already think there's something interesting there just about the clash between copyright norms and norms or practices in the world of dance. So let's start with, and my paper starts with this example, or it's in my blurb. It says Gangnam Style. I don't know how many people have not heard of it. Good, I'm impressed. Okay, good. I'm not going to demonstrate the dance, but I will if you forgive me. I'm going to keep my eye on the clock, but I'm going to maybe try and show you a few examples online. Now, I don't know if the volume's right, so if I dash over there, it's just to make a correction. But this is the famous video. The background is that in the summer of 2012, South Korean pop musician Psy released this music single. By the end of 2012, his music video was the first one to attract 1 billion views on YouTube. It now has over 2 billion views. So let's just take a quick look if you're not one of those 2 billion people who have watched it before. Let's see, we want to get the key. There are some key choreographic moments. Okay, that gives you the idea. Probably about as much as you want. Okay, so what was funny was that the video itself, many people applauded Psy because he was willing to, he was a YouTube star, right? And he became famous because he allowed the video to be posted and to be shared without restrictions. And then he had a deal with YouTube, as you now can do, where there's advertising. And so he's made over about $10 million just on the advertising revenue from the unauthorized YouTube streams. Okay? And so we talked about this a lot when we were talking about music and music videos, but what was interesting to me was one of the keys to the success is obviously the choreography, that crazy horse riding dance, and yeah, I'm not going to demonstrate, I promise. But yes. Later. But yeah, so that was, the key to the success in a way, and yet that we weren't talking about that as a separate choreographic work. So you've heard, so now of course, if you actually search YouTube for Gangnam Style parodies, it returns over 1 million results. And so everybody is making parodies. We had one at York University where someone ran through the cafeteria doing this dance. This is the NASA one. There's one from MIT that features Noam Chomsky doing the horse riding dance in the middle of a lecture. Like, it becomes an internet meme. So everybody's using the music, but they're also reproducing the choreographic work. Now, it's not actually Psy who owns the choreographic work. You might have heard of him, but have you heard of Lee Soon?
말씀을 처음 수행하고 만든 사람은 아무가 이주선 씨. 그는 싸이 일찍 때부터 함께 작업에 참여하며 화제가 된 싸이의 춤 동작들을 만들어 왔다.
예, 이게 손을 왜 이렇게 만드냐면 이 채찍을 갖는다고 해서 말에 채찍을 젓는다 해서 이거는 잘려.
Okay, so in other words, there's someone else behind the choreographic work. Now, apparently, Sujun was paid for his hour in the studio, or a few hours in the studio. And initially that was it. They didn't know it was going to be raking in millions of dollars globally. And then I think I understand that Psy paid him a cash bonus or something. But it's not like he's getting the royalties from YouTube when people are performing the dance. Why not? And he has gone on to complain about the fact that there aren't structures to allow choreographers to recoup when their works are reused. So I think there are 2 lessons here that I want you to take from this. One is, let me see if I can get back to where I was. One is that we don't tend to think about dance when we think about copyright. But copyright applies to dance. So there's something in that gap that's worth investigating. The other is that even when we acknowledge that this might seem, there might be some inequality here between different kinds of creators, if we imagine the creator of a dance exercising the power to prevent members of the public performing that dance, that seems kind of absurd, right? So the idea, could it really be true that copyright law would prevent a person from jumping around in public like he's riding an imaginary horse? Yes. Is it really true that copyright can allow one person to control what others are legally entitled to do with their own bodies? Yes. And how does that work? How does that work in the context of a popular dance craze where success in choreography means not just that everyone's watching you do the dance, but that everybody is doing the dance, right? And they're recording themselves doing it, and they're posting it online. So we have this massive mismatch between what copyright law says can happen and what actually happens without any interruption by the law. Okay, and there's another recent example that I want to bring to your attention, which is the electric slide, which is an example of a work that one choreographer has tried to control, claiming that he is the original, let's go here, he is the original choreographer of the electric slide, which you might know, you may have done, some of your less fine hours. It's very quiet compared to the other one. Okay, you don't need to hear him. As you can see, he's also not the world's best dancer. Okay. So the electric slide is a dance, a line dance that's done certainly throughout the US. And this guy, Richard Silver, is so infuriated because it's supposed to have 22 steps. And other people were posting videos of themselves online doing it with 18 steps, which was a modification to the prejudice of his honor and reputation and a reproduction that he did not authorize. Okay? And so he was issuing takedown notices to everybody who'd posted themselves, even at weddings and family parties, doing the electric slide. And then in the end, they negotiated some kind of settlement with the Electronic Frontier Foundation's help to mean that you can post a video of yourself doing the electric slide, but you have to include choreographed by Richard Silver on the posting, or it will be brought down. Okay. So I think that's a good example of what I mean to imply when I say that this kind of control over the interpretation of other people's dancing in the context of dance culture seems antithetical to social norms, cultural norms, and the cycle of creativity. Okay, questions? Comments?
Could they be sued for using 18 steps instead of 20?
Yes. Well, it doesn't help them if they say they use 22, because then they just reproduce the entire dance, and that's unlawful too. The point was that he only really cared that they weren't doing it right, and they were calling it the electric slide. So that's who he was choosing to go after. This is in the States. In Canada, he would also be entitled to say you're not allowed to modify it in that way and assert his moral rights to prevent people from doing the dance wrong in public. Yeah? You would think, right? So an interesting side note, so the question is whether that would affect freedom of expression, and I've mentioned what people can do with their bodies, how people can express themselves, and my answer is absolutely yes. But in Canada, we don't recognize the extent to which copyright might clash with freedom of expression rights, because our courts have said, oh, this is about property. So you don't have a right to express yourself on private property. And since we see the copyright work as just a piece of private property, you don't have the right to use someone else's copyright-protected work to express yourself. Yeah. Sorry, that at the back. Yeah.
So, if they just do a color that is fine, and they come with something else, or number 1 or 2, so the most the problem was when they called it, when they named it?
No.
Just because they did.
Yeah, I mean, it's a good question, and I think that's how he was identifying it for the takedown notices, was that if someone said electric slide, they would get the automatic takedown notice through the US structures for taking down unlawful content. But no, the electric slide isn't actually protected by copyright as a name. That's protected by trademark, if anything, and only if we recognize it as being something that suggests it's Richard Silver's version. So actually, it's about the steps that are being performed. It's got nothing to do with the name.
Done a choreography on the dance, but only had it performed in a country where the copyright law was more congenial. Would that work? Or
Congenial to whom?
to his protection.
Yeah.
Even though he didn't live there, and the brain is here.
Well, the way it works is kind of it's a national treatment principle, so he can assert his rights in any country that's a member of the WTO, and they have to recognize his rights, at least to the same extent as they recognize their citizens' rights. And there are commitments to having a certain level of protection for everybody. So in the US, they don't have performers' rights as such, but they have the copyright in choreographic works, as does every other nation in the WTO and most industrialized nations around the world. Yeah, so you can do that to an extent, but it's quite hard to make a difference. Yeah.
What defines him as the original choreographer? How does one determine whether he is such?
Excellent question. So what defines him as the original choreographer right now is that he says he is, and he sends out cease and desist letters telling other people that he is. But this is just a question of evidence, right? So to your question about registration, he doesn't need that. He finds himself in a court of law. The problem with copyright is most people don't get there because they get the cease and desist letter and think, okay, I guess I'm not going to do that. But if he finds himself in a court of law and they put into question the authorship of the dance, he would have to bring evidence to show that he's the author. The presumption would be in his favor, but if someone else could come and say, you know, I actually have a video of people doing a dance that looks very much like this before he claims to have choreographed his own dance, that would be evidence to the contrary. And if he's not the author, he's not the owner, he has no rights, he can't win. Yeah?
You know, what you just said now, that could apply for absolutely everything, because it's the principle that there is nothing unique.
Mm-hmm.
And who's going to try to define uniqueness, because basically there is nothing unique. We are all building in some place onto something else. So if somebody were going to sue somebody else for the person who is being sued, I would suggest that that person go the reverse and say, this aspect I found in ancient Greece, this aspect I found, so there's nothing unique about what you do.
Yeah, that's exactly right. And there are actually copyright cases that look a lot like that, where the defendant is saying, actually, I took this from here. Actually, if you listen, yes, this sounds a lot like the plaintiff's work. It also sounds a lot like something Vivaldi wrote. And then if they convince the court that it sounds as much like Vivaldi as it sounds like the plaintiff's work, then again, their defense will stand. It's an independent creation and there's no infringement. But again, the question is getting there, and the risk that if there's evidence of access, evidence of the potential of copying directly from the plaintiff's work, it puts the defendant in a difficult situation trying to say, yeah, I saw that, but actually my inspiration came from there. But it's just a messy evidentiary question like anything else in law, right? At the back, yeah?
So it seems to me that one aspect of copyright that's similar to other forms of intellectual property is that the enforcement is not the state, the enforcement is the owner of the piece.
Mm-hmm. Yeah, that's right. So it is a part of our private law in that way. So really it's the person who claims ownership who has to bring the legal action to prevent someone else from doing something. The only thing I'll say is we're moving farther and farther away from that model and more towards the idea that either at least the intermediaries, whether it's like Rogers or your ISPs and your internet service providers, should in some sense be policing for copyright. They should be taking down anything that goes up that looks like it might be unlawful. They should be making sure that defendants are notified. That's a big critical question in copyright policy today. And the other tendency is towards looking at states in the international regime and saying the state has an obligation. And we see that with the recent anti-counterfeiting bill, more and more pressure being put on Canada and other nations by the US to police their borders, to actually start taking and spending public money enforcing intellectual property. And that changes the very nature of the beast, right? So that's an important thing to have our eye on. Okay, thank you. So let me just go back to this for a little bit and we'll see how much further we can get. So we have, this is a wee bit of a detour perhaps that we needn't take now. But one of the questions that were troubling, and I think through this issue you raise, is how we apply this concept of originality to choreographic works. And I think that's implicit in the examples we've looked at so far as well. So first of all, I'll just say whether choreography was really a work of art or intellectual work that should be protected was long debated. It was a late entrant into our copyright system, and this is a fun quote about to call this dance a dramatic composition is an insult to the genius of English drama. It is merely spectacle. Okay. It may be an attractive or gorgeous spectacle, but it's nothing more than that. Okay, so, and then choreographic works were added explicitly in 1976 in the US. In 1988, it was made clear in Canada that there needn't be a storyline. And as I say, we've seen recent additions of performers' rights and then moral rights. But what is it that copyright is protecting when it protects a choreographic work? Well, it can only protect what is original in that work. So this is a statement. In Canada, the definition says a choreographic work is any work of choreography, which is about as helpful as the Copyright Act gets in helping you interpret things, right? This is the US statement, which says it's a composition or arrangement of dance movements and patterns, usually accompanied by music, successions of bodily movement in certain rhythmic spatial relationships. It's pretty hard to define what dance is. We know what it shouldn't include, because it ought not to, are basic dance steps. So the fundamental sort of building blocks of dance, the waltz step, the hustle step, the second position of classical ballet would not be protected. Okay. But what if you take some of those classical ballet things and you just string them together? So it's not one position in ballet, but it's glissade, glissade, assemblée, pas de chat. Well, that might be a common combination. At what point does that become an original combination that requires skill and judgment, such that what you have is a protected choreographic work? Even more complicated now is the suggestion that choreography just is not some kinds of bodily movement strung together. So there was a recent case, and it's ongoing, where Bikram tries to assert copyright over Bikram's yoga. I think it's 24 different poses or something. So the only people who are licensed can actually do or teach Bikram's yoga. And I think in an effort to get around this, we're told, well, not the mere compilation of physical movements. That's not necessarily choreographic authorship. It's got to contain attributes of a work of choreography. Well, so again, what is that? And you can't just say, well, it's not set to music. Because that means if you choreograph a ballet, but it's performed in silence, that's not a ballet anymore, that's not choreography, so it can't be that. And there are all these other distinctions. It's not like sports moves. If you put together sports moves, that can't be choreography. Well, there are good policy reasons why you wouldn't want to protect sports moves as choreography, but it's very hard to explain why these pre-planned physical movements are different from those pre-planned physical movements. Is it just that it's competitive? Well, lots of dance is competitive now. I watch Dance Moms. It's competitive. So, it's very hard when you get to it to think about what is choreography. Then we think about what originality is. When you have these traditions where dance steps are being repeated over time, they're arranged in the same way, you take the same steps, you just reformulate them a little bit, but all constrained by tradition and genre and the physical limitations of the dancers, what is it that is the original expression that copyright is protecting? Okay. And then we have the idea of this independent creation. Okay. We're looking for the great author, the man, I think it has to be a man, right, to be great author? The man from whose mind. My other work is on feminist theory and copyright, just to flag that for you. And my argument is that this is a very masculine notion of independent creation from the independent genius of the male author. Okay, so here we have, and I think it's interesting in ballet because you have the great choreographer, the male mind. The dancers are mere putty in his hand. He's the great sculptor. And then you have this dance performed on the bodies of the women. Are they authors? Are they creators? No, they're just his materials. Okay. So, but we have this presumption of independent creation, and my suggestion to you is that even the great choreographer, the Georges Balanchine, for example, the ultimate author genius figure, create works that are very derivative. His Nutcracker reuses much of Ivanov's work. Nothing is created from nothing. It's all nested within tradition and what has gone before. Okay. So what I have now. I'm trying to think of how best to spend our time. This is my suggestion, yes, about drawing from tradition and drawing from one another. The myth of independent origination in choreography. So these are just some key quotes. I won't go to the video for this, but in the jazz era, all the dancers would hang out. They'd trade ideas. We'd call it stealing steps. Everybody did it. That's how you learned. Or how far would dance have gone if people didn't steal from one another? It would have stagnated right in the spot. So this is thinking about the Lindy Hop and how that became, I don't know, there's lots of different kinds of dance, swing, how that emerged from the great tap dancers, and how working together in the clubs and learning and copying one another's steps, that's how creativity looks within choreographic communities. Even some of the most iconic, most original, most fundamental dance steps of our time are highly derivative. So let's just do this, and we'll show you. So this is Michael Jackson's famous moonwalk. Okay, pretty cool. This is the original version, arguably. Okay, so forget the fact that Michael Jackson didn't choreograph the moonwalk, that his choreographer did, who was incidentally also Madonna's choreographer, who choreographed her whole In Bed with Madonna tour. So if anybody is the author behind it, it's not Michael Jackson. But even leaving that aside, you can see that there's actually examples of the same steps in combination being performed by others well before that. But Michael Jackson's choreographer actually says, this is a fun video to watch, I won't play it, but it works through all of his sort of iconic stage moments and parallels them with old footage from old movies and other dancers. So you can see that nothing that he's really doing is original in that sense either. But they actually say, their inspiration was the popping dance that was being done by street dancers in California in the 1970s and 80s, that's the real origin of much of Jackson's style. Okay, and this is obviously still a very prevalent form of dancing that we see emerge through hip hop and all of the current crazies. Let me just say, what else do I have here while we're on this screen? Okay, I'm going to leave that for, oh no, I think this is actually a good place to skip to. So we also have the example of voguing. Now you might know it and associate it with Madonna, but voguing actually emerged in Harlem in the 1980s amongst the LGBTQ community, and these are some classic examples. Okay, you can skip through, there's a load of great ones. Okay. Now, in a sense, what she did is an example of the mainstream borrowing from subcultures, right? Taking something underground and making it part of the dominant culture. Now, is that cultural reuse, inspiration, or is it appropriation from a subculture? I mean, it really depends who you ask. But what you see and what we get a sense of throughout all of the examples that I've used anyway, is this kind of cycle or even spiral of borrowing, where you move from the subculture into the dominant culture, and then the choreographer copies what the kids are doing in the clubs and on the streets, and they take that to the star. They do it in a music video, it hits MTV or it hits YouTube, then suddenly everybody else is doing it, and so it goes on. Okay? At what point in there does someone do something independent and original? Who's to say? I won't play this, but Beyonce's Single Ladies is another good example of the internet meme that's now being performed from everybody from transgender performers to toddlers and flash mobs based upon that choreography. And this is the final example I have of this culture of sharing. It's the idea of twerking through time. So I don't know if you're aware of this particular phenomenon, but it made its way into the Oxford English Dictionary last year. So it's, well, I should maybe give a warning before I play it, should I? Okay, it is what it is. But one of the things that's interesting about it is even here, she's credited Miley Cyrus with twerking through time, with making this a craze. Actually, then Iggy Azalea from Australia says, I twerked first, so it's not really her, it's me. And then we go back, actually, the 1970s and 80s in New Orleans, the bounce scene was a very similar form of dancing, and then you can even take it to saying, well, actually, the Mapuka dance in Central or Western Africa is the origins of twerking. So nobody owns it. Who gets to claim that they are the author? Okay. I'm not saying that this culture of sharing and reuse and collaborative creativity is unique to choreographers, but I think it's fair to say that perhaps nowhere is it so fundamental to the practice and the evolution of the art form as it is to dance. The art of choreography is necessarily embodied, it is social, it's interactive, and there's something about the gap between that very innovative, very creative sphere of our culture where copyright norms have not really intervened. There's something to be learned about what creativity looks like when it's just allowed to grow and flourish and be shared amongst members of the community in this way. Compare hip-hop music, where copyright norms have intervened, have silenced, have changed and fundamentally shaped that music, to the realm of dance, where you see that freedom to create and to reuse. I'll end with that. Okay, so thank you for your time.